So we're now going to hear from Anna Kerr, who's the WDI country contact in Australia.
So I'm going to be talking about the case of Tickle and Giggle, which I'm sure everyone's already heard an awful lot of commentary on this case already. So I'll be talking very specifically about the decision, and if I use certain language that bothers you, it's probably because I'm quoting from the judgment. I'm just giving that warning. So this decision's just been handed down in the last, what is it, a week? Feels an eternity. So just to go over quickly, I'm sure most of you are familiar with these facts. This is the case involving Giggle and Sal Grover. So Sal Grover, having experienced sexual harassment and sexual assault during her 10 years as a screenwriter in Hollywood, decided with the support of her family that it would be therapeutic to set up a social media app exclusively for women and girls. And the app was specifically designed to enable women to meet safely online and network free of male harassment. It was, of course, under attack on a regular basis from males who attempted to register. But despite all that, it managed to accumulate about 20,000 users by 2021. Now, Roxanne Tickle, who's the applicant in this case, was a person who had various genital surgeries in October 2019. And then in accordance with Queensland law, Tickle's birth certificate was reissued with a female sex marker on the 18th of September 2020. These are facts taken from the judgment, by the way. In 2021, Tickle registered as a user with the Giggle app, having passed the gender detection system, only to be subsequently blocked and excluded some months later during a manual review of user profiles conducted probably by Ms. Grover herself as CEO of Giggle. And Tickle was at that point identified by Ms. Grover as being male. So Tickle then made complaints, sent emails and calls to Ms. Grover that weren't really responded to, and so then lodged a complaint with the Australian Human Rights Commission in December 2021. Tickle alleged discrimination on the ground of gender identity in the provision of goods and services. So this involves the joint operation of Section 5B and Section 22 of our Sex Discrimination Act, which is a federal piece of legislation. So as there was no prospect of conciliation, the Commission terminated the complaint, which then left Tickle with the option of taking the matter to the federal court, where the claim was ultimately heard by Justice Bromwich during a 3-day hearing in April. And then after 4 months of deliberation, Bromwich delivered his judgment on the 23rd of August. So Justice Bromwich found that it was, before I go to that, so look, this slide, which I hope you can all see both parts of it. So Sal Grover, this is like a summary, really. Sal Grover's attitude is law is supposed to reflect reality, and in reality, this person is a male, whereas Bromwich says the acceptance of Ms. Tickle is correct. The acceptance that Ms. Tickle is correctly described as a woman is legally unimpeachable. So there we have the stark difference between the two perspectives. Just to be warned that both the language and reasoning adopted by Bromwich demonstrated an uncritical embrace of gender identity ideology as propagated by both Tickle's legal representatives, but also the Sex Discrimination Commissioner. For example, Bromwich acknowledged at the outset that the term cisgender does not appear in the discrimination legislation and was opposed by the respondents, the Giggle team, and yet he proceeds to use this term no less than 30 times in his judgment without any sort of particular reflection really about that. Now, of course, Sal's view that the law should reflect reality sounds sensible, but those of us who are lawyers know that the law is full of legal fictions. So a legal fiction is a construct used in law where a thing is taken to be true when it's not in fact true. And this is done to achieve a certain outcome. I won't go into this. I've put a few on the screen, if you can see that slide, of some pretty well-known legal fictions. I would suggest that the courts need to consider really closely the implications of adopting these fictions. The law really rests on the telling of the truth, and I think we should, the legal system should lead by example. But it seems that at the moment, the law doesn't think reality should get in the way of a good legal fiction, to sort of paraphrase a quote from, I think, Mark Twain, who said the facts shouldn't get in the way of a good story. So lawyers have a similar view, it seems. So back to the details. So Judge Bromwich found that it was not established by the evidence that Sal Grover was aware of the applicant's transgender status. So when she took the decision to block Tickle, she did not know that Tickle was transgender. So accordingly, Bromwich found that there was no direct discrimination on the ground of gender identity because it just hadn't been proved. So that was a complete answer to the claim of direct discrimination. However, Bromwich then reasoned instead that Miss Grover had imposed a condition, the condition of needing to appear to be a cisgendered female in photos submitted to the Giggle app, and that this had the effect of disadvantaging transgender women who did not meet that condition, and in particular Miss Tickle. So that I'm quoting there from the judgment. So on this undisputed basis, Bromwich made a finding of indirect discrimination, despite observing that it hadn't been properly pleaded in the first place by Tickle's legal representatives. Throughout the judgment, Bromwich makes fair criticism of the pleadings and the conduct of the proceedings by both parties' legal representatives. So specifically, he complains that Tickle's pleadings do not coherently distinguish between direct and indirect discrimination. Bromwich also notes that the respondents failed to identify this shortcoming or to object to the amendment of the pleadings in this regard. So despite this failure to plead Section 5B2 clearly, the judge kind of works to correct this deficiency so that he can ultimately support his finding of indirect discrimination. So the court's less helpful when it comes to repairing the shortcomings of the respondent's case or the Giggle case. A claim of indirect discrimination enlivens another section, Section 7B, which provides a defence when the condition imposed, the condition, requirement or practice, that is reasonable in the circumstances. So unfortunately, the onus to establish that rests on the respondent. So they have the burden of satisfying the reasonableness test. Unfortunately, no doubt because they perceived the case as one of direct discrimination, the respondents failed to plead Section 7B and did not rely upon this defence in their submissions. Bromwich didn't repair this shortcoming, despite the fact that really the respondents could have won the case really by default had he taken an equally rigid approach to the failures of Tickle's legal team. The evidence in the proceedings provided an ample basis for the argument that the condition of excluding males did not result in any real disadvantage to Tickle, who had in fact conceded in evidence that he made very little use of the app and he found it boring. Furthermore, multiple affidavits tendered into evidence by the respondents, which appear to have been dismissed in a rather cavalier fashion by Bromwich, but they all provided extensive support for a finding that the condition imposed was proportionate and reasonable to ensure reliably safe single-sex spaces for women free of male harassment. But he didn't give that his attention. So instead of pleading Section 7B, the respondents had relied very heavily on another section, Section 7D of the Sex Discrimination Act, which provides an exception from discrimination provisions for special measures intended to achieve substantive equality. This section enacts Article 4 of CEDAW and makes provision for affirmative action provisions. In other words, you can have discriminatory provisions where they're intended to help a disadvantaged group achieve substantive equality. So things like quotas and affirmative action measures. However, although Bromwich accepts that the Giggle Act may constitute a special measure when it comes to the exclusion of cisgender men, he does not accept it as a shield to guard against claims of discrimination on other grounds, such as gender identity. Since Bromwich accepts that trans women fall into a category of women, he cannot countenance the respondent's argument that Tickle was excluded because and only because he was a male. Interestingly, Bromwich does not seem to consider whether there could be a claim made for a special measure on behalf of cisgender women to exclude those who identify as trans women. This is perhaps because cisgender women are regarded as the more advantaged group, despite the fact that their spaces and services are entirely excluded from funding and acceptance if they do not agree to embrace gender identity ideology. Ultimately, the difficulty is that Bromwich uncritically accepted and adopted the submissions of the Sex Discrimination Commissioner, who those submissions were, firstly, sex is not confined to a biological concept. Secondly, sex can refer to a non-binary status and can be changed. Thirdly, the determination of sex can take account of legal and social recognition. And fourthly, the sex discrimination provisions must now be read in the context of the amendments to the Sex Discrimination Act in 2013 that added gender identity protection. So Bromwich accepted all of that, saying that it was grounded in logic and long-standing authority. In contrast, Bromwich finds the expert reports relied upon by the respondents, the Giggle team, as to the immutable nature of sex from both scientific and philosophical perspectives, with reports from both evolutionary biologist Colin Wright and academic Kathleen Stock, to be of no use to the respondent's case. Bromwich also rejected journalist and author Helen Joyce as an expert. He rejected her as an expert altogether, despite her having authored a book on trans when ideology meets reality. But he found that she had no formal qualifications of relevance. He stated instead that she is entitled to her opinion, but it is of no assistance to the respondent's case or to this court. So I suppose we should be grateful for this small concession that she was entitled to her opinion, because we're increasingly in an environment where we feel as if we're not entitled to an alternative opinion on this subject. Increasingly, we're being told that dissent on this topic can constitute hate speech. The respondents, when I say the respondents, I'll just say the Giggle team. The Giggle team also tendered 14 affidavits of lay opinion, ordinary people's opinions as opposed to experts, often on the crucial importance of female spaces, and these were similarly dismissed by Bromwich as having no bearing on the matter. There was no cross-examination of any of the respondents' experts or lay witnesses. Instead, the court relied on case law going back over 30 years, which Bromwich states has broadened the concept of sex, leading him to claim the acceptance that Ms. Tickle is correctly described as a woman is legally unimpeachable. Strangely, Bromwich didn't enter into any detailed analysis of the case law in question, despite it really being at the crux of the case. He just simply accepted the submissions of the Sex Discrimination Commissioner, and we're really left curious whether he had an independent view of the authorities cited. Of course, there is another section of the Sex Discrimination Act which was was not pleaded and received no attention in the judgment, and that is section 32, which states that discrimination provisions do not apply to the provision of services, the nature of which is such they can only be provided to members of one sex. I would think that that could provide specific protection of the kind needed by the respondents, but this provision was, of course, going to be rendered inoperable by a finding that Tickle was a female. So basically the respondents had argued that Tickle was excluded on the basis of sex rather than gender. That argument was rejected because Tickle was accepted as being a woman and that his claim was on the basis of gender identity. Tickle was not claiming to have been treated less favourably than a man. Tickle was complaining about being treated as if he were a man. So a key defence of the respondents was to challenge the constitutional authority for the 2013 amendments to the Sex Discrimination Act, which introduced the protection of gender identity. The Giggle team argued that CEDAW does not extend its protections to gender identity only to sex, and therefore the amendments are not supported by the External Affairs head of power under the Australian Constitution. But Bromwich found that CEDAW just wasn't relevant at all because the convention does not extend to protecting one category of woman from another category of woman. And because he'd found that Tickle was a woman, therefore it had nothing to do with CEDAW. Instead, Bromwich referred to the fact that the gender identity provisions are supported by the more broadly worded Article 26 of the International Covenant on Civil and Political Rights. This article protects against discrimination on various grounds, including other status, which Bromwich was convinced does include gender identity. So he dismissed the respondents' arguments that Article 26 is too general and vague to be relied upon and accepted that. In any case, Bromwich also found that Giggle is a trading corporation. And in fact, as a trading corporation, the Commonwealth can make laws in relation to it under another head of power under the Constitution, really rendering all these arguments in relation to the external affairs power somewhat redundant. There was a second constitutional argument that was put. This one, it related to there being an inconsistency between the Federal Sex Discrimination Act and state laws which allow for change of sex on birth certificates. The idea is if there's a state law that's inconsistent with a Commonwealth law, then it's going to be invalid to the extent of that inconsistency. So the Giggle team argued that, in fact, being able to change sex created an inconsistency with the protections of sex under the Sex Discrimination Act. However, of course, the 2013 amendments somewhat undermine this argument since they removed the definitions of man and woman. But Bromwich said that even if those definitions had remained, there would be no inconsistency because the Sex Discrimination Act is not exhaustive and it does not impose its definitions on the states. So even if we had those definitions put back in, which I think Claire Chandler was attempting to do at one stage, it wouldn't be a problem. So the bigger problem that we have is that the states have now almost, basically all of them have now allowed for change of sex on birth certificates. So Bromwich really dispensed with all these arguments really quite quickly with really very little angst, considering the complex constitutional and philosophical considerations about the nature of sex and its protection. But he then spent 10 pages of his judgment on a detailed legal analysis in relation to the assessment of damages. And that's quite peculiar considering that Tickle didn't put on any expert evidence to quantify the loss claimed. He didn't put on anything from a doctor as to the exacerbation of his pre-existing psychiatric condition, and generally failed to provide specifics or justify seeking the amounts of $100,000 in general damages and $100,000 in aggravated damages. However, the Giggle team can be grateful that by rigid application of a certain section, I won't bore you with, Bromwich found that it was inappropriate to make any award of aggravated damages. Basically, we're saying that the complaints that related to actions that took place after the lodgement of the complaint shouldn't attract damages because they weren't part of the original claim. So instead, the court ordered a payment of only general damages in the sum of $10,000. So this is considerably less than Tickle's ambit claim, but it's still arguably a grossly excessive sum for findings of modestly hurt feelings and the loss of access to a social media app, which he admitted to having made minimal use. So Bromwich recognises this was a case brought on principle rather than due to any lasting hurt or disadvantage. So really should have acceded to the respondent's submission that an award of damages should be nominal. Due to the complete lack of evidence and precedent upon which to base an assessment of the quantum of damages, Bromwich relied instead upon an instinctive synthesis to make his award, and after considerable thought and reflection, reached into a hat and pulled out $10,000. It's to be wondered whether that thought and reflection included considering that $10,000 is the maximum recognition payment available to women in New South Wales who are primary victims of sexual assault, resulting in serious bodily injury or multiple offenders or an offensive weapon, etc. So I don't know, but perhaps it was Ms. Grover's conduct in court laughing at an offensive caricature of the applicant that convinced the court that this offensive and belittling behaviour should result in an award commensurate with the amounts paid to victims of violent sexual crime. I don't know. However, this was that would be arguably inconsistent with the statement made by Bromwich at the outset that the court has power only to compensate, not to punish the respondents. In any case, the award of costs against the respondents is definitely going to be far more punishing than the compensation to be paid to Tickle. And these awards are awarded by the court despite not having been originally sought in the applicant's pleadings, and they're only partially capped. The cap of $50,000 only extends to the work that is involved in the constitutional and statutory construction arguments, not to all aspects of the case. Originally, there had been, the applicant had floated a general cap on costs of $20,000, but unfortunately that was rebuffed at an earlier stage by the respondents' team. Sensibly, Bromwich declines to order a forced and insincere apology or to order Tickle's reinstatement to the now defunct social media app. The wording of the declarations to be made in Tickle's favour are yet to be finalised after consideration of proposed wording by the parties. And that's the end of my slides. So look, just to conclude, Bromwich now has the very dubious honour of being the first judge to decide that it is possible to change sex in a context where the result of his decision is to directly destroy any prospect of women and girls continuing to enjoy safe single-sex spaces and services. While laughable in its reasoning, the implications of this decision are no laughing matter. I think I'll stop there. Thank you.